Thank you. I'm very pleased to be here and to have been invited to join the panel with our distinguished guests. Maybe we could start with just a few summary, since the talks were videotaped. Maybe we could start with just a few comments from each of the panelists on their talks and how it relates to the other panelists that we've heard speak today. Joanna, would you like to start?
Of course, thank you so much, Ken, and thanks to all for attending. So in terms of intellectual property and agriculture in Canada, I think we are trying to balance many interests within our country and facilitate as much commercialization while balancing those rights with some of the other interests, in terms of international commitments and international collaboration as we can. Thank you.
Yes, thank you, Joanna, and Dr. Yu-Chao. Yes, you're mentioning that the purpose of the patents are directed first inwardly towards the domestic market. It's very appropriate for what I talked about today. I talked about how IP laws in the U.S. Affect U.S. practice, but also there's spillovers to the rest of the world, and I think you made that point effectively. So, do you have any further summary comments of how your talk fits in with the others?
Yeah, thanks, Dr. Porter, for your acknowledgement as well. So basically, like US, right, if we go to ITC 337, even as the infringement established, there will be a very critical portion that we need to take into consideration is the level of influence to the domestic market. So that's the reason why it also applies to most of the Asia countries. As I mentioned in my presentation, most of the Asia countries still in they have to spend a lot of money in order to get licensing from Western or like a US, Japan, or Germany to get a technology license. So this is also the reason why that in Asia countries, when we introduce or when we establish our IP law, we need to take into consideration how to find a balance between the industry development and the IP law. So I think this is an art than science, but we try to compromise it and try to find a better way, how to find the balance between among different stakeholders. So I think this is also the reason why I use equity and the efficiency, because in essence, it's two is conflicting view, but we try to balance it. And this also, as a policymaker, is very difficult to achieve. Yeah, thank you.
Yeah, thank you. And Dr. Xu, you kind of took the next transition as far as going from intellectual property to the markets as well. And so do you have any further words for us? You're on mute. You're on mute, Dr. Xu. Dr. Xu, you're on mute.
Can you hear me?
There we go. Now we can.
Okay. I think one of the most important concepts is agricultural product used to have a lot of trade barrier, okay? And every country thinking about protecting their own agricultural produce by rejecting importation of other countries' agricultural products. So there are a lot of dispute. Traditionally, we have a lot of trade negotiation and et cetera, et cetera. But I think the new concept is due to the fact that many parts of the world are facing the food shortage or encountering with the problem of food safety. So under the circumstances, we should be innovative in promoting another trade, that is trade of technology. But the technology owner, they are afraid their technology will be copied without having any income. So how do we do that? So I think it's important to come up with a new business model. So I'm really promoting new business model to enhance the agricultural technology trade around the world. And when I use Coca-Cola as an example, I think that's an excellent example. Their cereal is protected by trade secret. They would never let anybody know the trade secret. But to come up with a business model that is called bottling plant. And people wants to make money with Coca-Cola's business, yes, they have a business model. And one is they will sell you a bottling plant. And secondly, they would ask you to pay them for the trademark license fee. And then they probably would charge another fee for the technical support, like there's syrup will be blended with how much water, how much CO2, and maybe there are other ingredients, but you had to buy their syrup. So they using a business model, they can create multiple income. But at the other end, it's resolving the food shortage program or hunger program in the recipient country of the agricultural technology. So how do we accomplish that? By creating many, many different business models and encouraging the technology, agricultural technology can be a subject of commercial product. So that's why I'm been emphasizing how to commercialize agricultural technology, but it has to be beneficial to both parties. Okay, for instance, Taiwan doesn't have too much arable land, and Taiwan doesn't have enough labor, but Taiwan has a lot of agricultural technology as a result of years of research, and also based on the innovation of the farmer themselves. So how do we enhance a new business model so that the Taiwan agricultural technology can also benefit other countries? But also, of course, the big question is who pays for that technology? Okay. Now, instead of shipping agricultural produce from one country to another country, now currently we are facing the problem of seeing how difficult it is to export to ship the Ukrainian wheat to Africa. Okay, if it doesn't happen, the people are starving. We never realize how big the problem is now that we didn't realize before. So now I think the enhancing the agricultural technology transfer probably is one of the solutions. So that's why from Taiwan's standpoint, we have a lot of agricultural technology, but we still heavily rely on export of agricultural product. I think that's wrong. That's why I want to make some differences. Okay.
Thank you. Mr. Chen, do you have any further comments?
Yes, Dr. Porter, thank you. And thank you for the organizers for including me on this panel. No, I appreciate all the panelists. I think the importance of understanding the different IP regimes in various jurisdictions is really important. As Dr. Cheng was mentioning about the balance, obviously our world is evolving with, the shortage of supply chain. We're seeing kind of the results of just the pandemic and how that's caused an impact on our agricultural kind of ecosystem, and the importance of intellectual property, the protection of it, to drive innovation, to drive commercialization. I'm glad to see that this panel is a mixture of university and kind of an industry perspective. I think it's important for universities and industry partners to partner together to develop technology to solve kind of the crisis that we're in. One of the things I think I would add is the harmonization of the IP regimes around the world. A number of important, or I'll say number of countries have banded together to develop harmonization of IP rules and laws, which facilitate IP development, whether it's trademarks or patents or copyrights, trade secrets. And so an understanding of that by each of the attendees, whether you're in industry, whether you're in university setting, or just a sole farmer, understanding the benefits of using intellectual property to protect innovation.
I agree. Ms. Hurley, do you have further comments?
Yes, thank you. Thank you so much for including me today. It's been very, very good information, good discussions. I have to say, I think that something that kept resonating with me is Dr. Cheng mentioned is the balance. I feel like we deal with that very, very much. And especially in the agricultural industry, I feel like we can see much more perhaps criticism or resistance to intellectual property and commercialization, especially from the university. And we can get critics saying that, you know, as a university and operating largely off of taxpayer dollars, then we're viewed as operating more like a company that, you know, and we're pursuing intellectual property rights and asking for royalties back when we commercialize technologies. But I think awareness is a big thing in our operations and why we do what we do, because people need to understand as a university, we don't have the means to be able to, you know, fully develop and distribute products and things like that. And there's a misconception sometimes that the university is just greedy and trying to get more money, but you know, really our primary objective is seeing new technologies reach the public. I mean, that the public is our stakeholders, especially I'm at a public, you know, institution, and that's very, very important to us. And so having the partnership with companies to be able to do what we cannot do as a university, and then take a small portion back to continue to, you know, leverage our research programs and continue to innovate, I think is very important, and it's very important for the ag industry. I agree also with Dr. Hsu that we need to keep our mind open about other models for being able to commercialize our technologies, and continue just to keep an open mind when there are opportunities, because I don't think in the ag sector that we have had as many startups and pushing that way as you see in, you know, the health sciences and maybe engineering and things like that. But there are opportunities as well in ag. And so I think it's, you know, not everything makes sense to go into a startup opportunity, but I think it's very, very good for us to keep that in mind as a possibility.
Thank you, and I agree with you on a lot of those points. I think as far as, you know, what good is intellectual property and technology transfer in academics? Well, one the protection attracts investment, so I think most people would agree on that. But as well, in general, intellectual property and technology transfer brings attention to technologies and accelerates their development. There are a couple of great examples of that. One, the foundational patent for the biotechnology industry, the Cohen-Boyer cloning patents, were published in a prestigious journal, Proceedings of the National Academy of Sciences, and nobody paid attention. And a year later, the New York Times picked that up, and from the New York Times, the Stanford Tech Transfer Office picked it up and filed a patent, like on the last day it was eligible. And from that patent, I think it was Herbert Boyer who said he thought it would take 20 years for cloning to become commonplace, but through the patents, Genentech was started and the patents were licensed 9 years later. Johns Hopkins, our neighbor here in Maryland, invented the kidney dialysis machine, and it wasn't patented, and it wasn't picked up for about 10 years for industrial use. And so all the lives lost due to the languishing of the technology is what happens when people don't have an active interest in innovation. And Dr. Yu-Chao, as far as innovation, you mentioned non-practicing entities, and so those are groups that don't use that use intellectual property just for profit motives, not for innovations. And so one of our values here at the University of Maryland, and I think in academic technology transfer in general, is that we use intellectual property as a tool for innovation, not for carving out space, not for carving out intellectual space and protecting it and reserving it for others, either for research or for profit. And here in the United States, the patent troll non-practicing entity issue was a problem like in the early 2000s, but laws were passed in the early 2010s that largely put an end to that business model. And I was wondering if our non-US panelists could comment on how they see this issue across the world. And I'll let you guys just jump in when you have something to say. Maybe Dr. Yu-Chao, since you mentioned it in your talk, you could start us off.
Yeah, sure. Thank you. So I would like to share my thought on that. So basically, non-practicing entities is a business model, as you mentioned, and I think to some extent it's like a necessary evil. Please allow me to say that. This is because when I think because like the intellectual ventures, I think most of you guys know, right? There are a lot of huge big patent portfolios. They'll also have their arm in the Trans-Pacific in Asia, but basically to some extent, we have to admit that how to attract the attention, how to ask the stakeholders to value the intellectual property, actually, unfortunately, is the litigation. We try to educate the public, try to ask them to increase the level of IP awareness, but as long as the boss receive the complaint later, over one night later, they can understand the knowledge in a short period of time. So our question is like in non-practicing entities, does it really bad things for the whole ecosystem, or they just be bad things for just a small portion of the entities? So if I say in my view, I think we have to admit that NPE to sometimes drive the utilization of the intellectual property. However, on the other hand, if you are big companies, you are really practice this patent, practice those IPs, you may quite hate this kind of entities. But no matter we like it or not, it's already play a critical role, a vital role in the whole IP ecosystem. So this is roughly what my view on it. It's called troll, right? Troll is usually like in our children's history. So when you want to walk across the road, the troll will jump out of the bridge and they say that, okay, give me money, otherwise I will not let you go. So this is the source of the troll. And yeah, I think it's like a necessary evil, but it's already, we have to admit that this is all part of the ecosystem bodies. Thank you.
Mr. Chen, do you have any comments on this topic?
Yes, I agree with Dr. Yu-Chao. I think one thing that we've seen with litigation in China is, as Dr. Yu-Chao noted, the increase in NPE litigation. In the United States, Dr. Porter, as you noted, the evolution of NPEs has waned, which is good. But as a result of kind of that process, a lot of the smaller players, not just the big companies, were getting affected, right? The non-NPEs were going after the larger companies, and then it was kind of a trickle down effect in terms of the allegations that these NPEs were making, to smaller companies. And we haven't seen that, or at least from my experience, we haven't seen that in China, for example, yet. I think with the kind of, again, going to the evolution of the litigation system in the US and China are working very collaboratively from the IP standpoint. The various IP courts, the Beijing IP court specifically, are in collaboration with the US court system to kind of develop various protocols and practices to minimize the impact of NPE. So we haven't yet seen that play out yet in China, for example, but those are discussions that are happening. So hopefully we'll see that happen quicker in a positive way. But I agree with Dr. Yu-Chao, the balance in the ecosystem of having an
Dr. Xu, do you have any comments on this topic?
Yes, I think Mr. Chen and I are both trained as a lawyer, and I practiced law for many years, but now I want to turn into a more challenging area, that's designing business model for my client. Now, under the circumstances, I think we were talking about intellectual property protection, and don't forget trade secret is also a part of the intellectual property. But then you don't want anybody to know. Now, how to protect that? So I use Coca-Cola as an example. We can use that example applied to many other. For instance, you want to export agricultural farm from one country to another country. So one thing you probably don't want to let them know, that's trade secret. But you say, okay, but you can enjoy my product, which is protected by trade secret. You can only buy them. Okay. So I think Coca-Cola syrup is a good example. It's protected by trade secret. Okay. They never license to anybody, and they would protect that formula. Okay. Using whatever effort they have for generation and generation. But if you want to invest in a Coca-Cola plant in your given country, they say, fine, we welcome that, but you have to buy the syrup. Now, how do we use an example and build into a agricultural technology transfer to business model, and that ensure nobody will steal anybody's, if there's a patent, if there's trademark, or we will sign agreement for licensing agreement, but at the end you have to buy the syrup from Coca-Cola. Yeah, Coca-Cola business continue growing, okay, and they constantly develop a new product to ensure they are still growing. But we can use that thinking and put into many other agricultural technology, so that poorer country or even rich country can share with other people's agricultural technology. But we have to design, various business models. So that's a challenge, not just for businessmen, but also a good challenge for lawyer or consultant. Okay. So I think we can open a new arena to resolve the food shortage program and food safety program that is prevailing the whole world right now.
Yeah.
Thank you.
So Prof. Porter, so sorry about it. I should not ask panel a question, but I would like to ask you a question, because in my course of my research, right? So I would like a question for you is, do you think university is considered as part of the non-practicing entities, or even some people say university is considered as a patent troll, because university, or even like the case, Ogura case, the French National Institute of Agricultural Research, right? Actually, the main purpose of it is for...
I have studied that problem in depth.
Oh, okay,
one of the problems is some government-owned university, they can claim, university research, government property. So if you license that, there is difficulty. But I work with MIT very closely. Their licensing program is great, and they have helped a lot of spin-off company. But all those spin-off company have using MIT developed technology, have to pay MIT whatever called royalty or license fee. So we have to start with the government. So the Bayh-Dole Act, somebody mentioned that during this conference. I think it's a wonderful legislation. But how many countries have been able to effectively copy Bayh-Dole Act? MIT colleague, MIT professor told me the Bayh-Dole Act helped MIT to enhance a lot of spin-off company.
Yeah, Singapore is doing the same.
How many universities are able to instigate spin-off company? So I raise a question to all of you. So talking about university research, how do you turn that into a gold mine?
I'd like to.
I don't know about Singaporean government allow that or not, but probably do. But many countries safeguard the technology within the your national-owned university.
Right. As far as universities,
they don't care about commercialization.
As far as patent,
this is what I've been stressing, that we need some changes right now.
as far as universities being patent trolls, there are several counter arguments there. I think the biggest one is that patent trolls use IP to make money, and universities use IP to innovate. Lesser differences, patent trolls are usually sector specific, and universities have completely diverse IP portfolios, so that's a big difference. Ms. Preston, a couple of the largest non-practicing entities in North America reside in Canada. Do you have any comments on how they might affect your practice, or how you differentiate your work from those of companies like Rockstar?
I think universities place a very high priority in general in ensuring publication in coordination with patenting. So we work very closely with researchers to ensure that if we are protecting intellectual property in order to facilitate transfer to the private sector, we're doing that in a way that really allows the dissemination of the information that's been generated in a very timely manner. We're not holding back publication. We do tend to favor, in my university's case, local licensing to small companies, and in particular spin-off companies. So we want to push our technologies out to the creators of those technologies or local entrepreneurs. We have streamlined licensing practices that are very investor and founder friendly to facilitate that. So we've managed to greatly reduce the turnaround time to transition innovation out of our institution in ways that really don't make us very much money, which we're fine with, because we're going for those regional economic benefits and rapid transition into products and services. So as opposed to patent trolls like Rockstar and other entities, we don't generally consider them as licensing partners for our technologies. In most cases, I would say the University of Alberta has probably never interacted with those entities.
Got it. And we're almost out of time. So Ms. Hurley, I'd like to give you the last word. We got a couple of questions along this line of discussion. One, that the holding of IP is a big problem as it holds back development. The other is that an institution withheld their intellectual property for anyone except alumni. So could you talk about the academic approach and the Texas A&M approach in general towards these questions?
Sure. So for us, it's very important, as I mentioned before, to see our technology developed and utilized. And so yes, our license agreements have financial terms, but more importantly is the development of the technology. And so we insist that whoever we're granting a license to, and I agree with Ms. Preston as well, usually we will look a little bit more locally initially, but ultimately we're looking for the company or companies that can best, develop and get a product to market. And we will be very careful to have provisions in our agreements that will require the milestones toward the development and ultimate commercialization of those technologies. And so we do not allow in any of our agreements a company to shelve basically the technology and not utilize the technology. And we're not allowed to license to these non-practicing entities. We require, evidence of a company having the sufficient capabilities to actually develop and commercialize the technology. And we place timelines around that to ensure that development occurs.
Right. Excellent. Excellent. I think that approach is shared by almost by all the academic institutions with which I am familiar, and even bleeds into a little bit of a gray area, the area of large tech companies like Intel and Facebook and Apple, who collect patents for defensive purposes, and we've been approached there. And try to avoid those models. Also, try to keep innovation as our guiding star. So thank you. We're completely out of time now, and thank you to all the panelists for very enlightening talks and a lively discussion. I'll turn the program back over to IAIC.